All right, let's talk. If you're a gun owner in America, the ground beneath our feet is shifting, and it's happening fast. It's not just one thing. It's a cascade of recent landmark court decisions that are completely rewriting the rulebook on our Second Amendment rights. The legal landscape has been redrawn, creating huge new protections for us while also laying out subtle legal traps that could catch even the most careful gun owner off guard. I've spent weeks digging through these changes, and I've boiled it down to the 10 biggest shifts that every single one of us needs to understand right now. So do me a favor and hit that subscribe button, because what you don't know can hurt you. Let's get into it. Enhanced Castle Doctrine, defending your home. Let's start where it matters most, your home. For years, the nightmare scenario wasn't just the home invasion itself, it was the legal battle that came after. You hear these horror stories, right? A homeowner defends their family from a violent intruder, and suddenly they're the one in handcuffs, facing a prosecutor who wants to make an example out of them. There was that case of a homeowner who shot a burglar armed with a crowbar. He had a violent record. The homeowner was arrested on the spot and spent 2 years and a fortune proving his innocence before he was finally acquitted. Well, the legal tide is turning. Recent rulings are flipping that script. The emerging standard, heavily reinforcing the Castle Doctrine, puts the burden of proof squarely on the prosecution. If you use a firearm to defend yourself inside your own home, the law is increasingly on your side. The prosecutor must now prove, beyond a reasonable doubt, that your actions were not justified self-defense. This is a monumental shift that treats the law-abiding homeowner as the victim, not the suspect. Civil liability shield, winning the second battle. So you've defended your life, and the police and prosecutor agree it was a clean shoot. You breathe a sigh of relief, but the fight's not over. The next battle is often in civil court. For decades, even after being cleared of any crime, gun owners have been financially ruined by lawsuits from the very criminals who attacked them, or their families. There was this guy in Ohio. He does everything right, stops a burglar in his house at 2 a.m., no criminal charges. Then, bam! The burglar's family sues him and wins a $400,000 judgment. It's insane. This is another area where things are changing for the better. Courts are backing the idea of providing gun owners with immunity from these kinds of predatory civil lawsuits. The logic is simple. If you were justified in using lethal force to defend your life, you shouldn't have to pay the person who forced you to do it. The trend is that before a civil case can even begin, the person suing you has to prove your actions were criminal. This is a firewall that could save you from financial ruin. Ammo storage mandates, a gun that actually works. Now, what good is a gun if you can't get to it in an emergency? For years, certain states have passed laws that sound reasonable on the surface, but are designed to make your firearm useless for self-defense. In Massachusetts, you had to keep your ammo in a separate, locked container from your firearm. California wanted your ammo in a different room entirely. One county in Illinois even required your guns and ammo to be stored on different floors of your house. Think about that for a second. You hear glass shatter downstairs. You have to run to your safe, get your gun, then run to another room, fumble with another key or a combination for your ammo box, load your weapon. All while the intruder is making themselves at home. It's a fatal delay by design. Courts are now striking these laws down, calling them what they are, an unconstitutional infringement. The new legal standard says that any law preventing immediate access to a functional firearm for self-defense is a violation of your rights. You have the right to store your guns and ammo together, ready for the moment you pray never comes. Carry permit timelines, an end to the waiting game. Okay, so your home is secure. But what about when you leave the house? For anyone living in a restrictive state, you know the game. You file your carry permit application, pay the fees, get your fingerprints done, and then crickets. 3 months go by, then 6, then a year. In places like New York, the average wait was over 18 months. It was a deliberate strategy to make you give up. That game is over. Thanks to the precedent set by the Supreme Court, states are now on the clock. The rule is becoming simple. States must approve or deny your permit application within a reasonable timeframe, often interpreted as 60 days. And here's the best part. If they fail to give you an answer in that time, your permit can be considered automatically approved by default. They can't just sit on it anymore. If they deny you, they have to give you a specific, legally valid reason in writing. This is forcing states to process thousands of backlogged applications, and people are finally getting their rights recognized. Sensitive places, taking back public spaces. So you finally got your permit. Now, where can you actually carry it? States like New York, New Jersey, and California came up with a clever trick. They couldn't ban guns outright, so they declared nearly everywhere a sensitive place. Parks, libraries, restaurants, public transport. The lists were so long, they essentially made carrying a firearm impossible. That strategy just got shut down, hard. Courts have established a strict, history-based test for what actually qualifies as a sensitive place. A courthouse with metal detectors and armed guards? Okay, that qualifies. A school with security and police? That qualifies. But a public park with nothing but a no-gun sign? Not a sensitive place anymore. A public library? Not a sensitive place. This is forcing states to slash their ridiculous lists of banned locations. While private businesses can still ask you to leave, this change reclaims huge swaths of public areas for law-abiding carriers. Carry reciprocity, erasing the borderlines. This one is a game changer for anyone who travels. For decades, our carry permits were trapped in this confusing patchwork quilt of reciprocity agreements. Your permit could be valid in your home state, but the second you drove 20 feet across the state line, you could become an accidental felon. People have been arrested during routine traffic stops just because they didn't realize their permit wasn't recognized one state over. The push, backed by major court wins, is for a national standard. If you have a valid carry permit from your home state, other states should be required to honor it. While we don't have a single federal law yet, the legal precedent is forcing more and more states to recognize out-of-state permits. The goal is simple. Your valid Texas permit should work in New Mexico, your Florida permit in Georgia, and so on. You should be able to drive across the country without needing a lawyer to read a map. Police accountability, shattering the shield. Let's talk about something that makes a lot of us nervous: interactions with law enforcement. For decades, a legal doctrine called qualified immunity has acted like a shield, often protecting officers from personal liability, even when they clearly violated someone's rights. For Second Amendment violations, that shield is starting to shatter. The new legal climate says that when an officer violates a clearly established gun right, they can't just hide behind qualified immunity anymore. If they confiscate your legally owned firearm during a traffic stop without probable cause, they can be held personally and financially responsible. Just recently, an officer in Virginia lost a $300,000 personal judgment for doing exactly that to a man with a valid permit. This isn't about being anti-police, it's about being pro-accountability. It ensures that our rights are respected by everyone. Gun registry bans, exposing the lists. All right, this one feels like something out of a spy movie, but it's very real. Federal law has explicitly banned a national gun registry since 1986. But several states found loopholes and built them anyway. California's dealer record of sale system was a massive database linking millions of specific handguns to specific people. Hawaii required every single firearm to be registered with the local police. These are, for all intents and purposes, gun registries. Landmark rulings are calling these what they are: illegal backdoor registries, and ordering them dismantled. The precedent being set is that any state-level system that tracks gun owners and their specific firearms is a violation of federal law and must be destroyed. States are being ordered to not only delete the data, but also to send confirmation to gun owners that their information is gone for good. FFL reform, protecting our gun stores. This one is for all the small, local gun shops we love, who have been under constant attack. For years, the ATF has been accused of using minor paperwork errors to revoke a dealer's federal firearms license and shut them down. We're talking about impossibly small mistakes: a transposed number in a serial, using blue ink instead of black, or writing the wrong year on a single form out of thousands. This weaponization of bureaucracy is now facing serious legal challenges. The new standard being pushed in court is clear. Revoking a license should be reserved for actual, willful criminal violations, not honest administrative mistakes. The ATF should have to issue a warning and give dealers a chance to correct simple errors before dropping the hammer. This levels the playing field and stops the government from using regulations as a backdoor method to close down gun stores. Strict scrutiny, the engine for every victory. Okay, we've covered 9 massive changes, but there's one final piece: the legal engine that's making all of this possible. For decades, when the government passed a gun law, courts gave them the benefit of the doubt. But no more. Now, because of the Supreme Court's Bruen decision, any law that touches your Second Amendment rights must pass the highest legal test that exists: Strict scrutiny. Think of it like this. It's the legal world's championship fight. And now, the government has to prove that their law is absolutely necessary to achieve a compelling government interest. The burden of proof is entirely on them, not on us. This is the standard that's putting thousands of gun laws across the country in serious danger of being thrown out. It's the legal firepower that makes every other victory we've talked about today a reality. So there you have it, 10 massive shifts in our rights. Knowing this stuff isn't just trivia. It's the difference between exercising your rights freely and ending up in a legal nightmare you never saw coming. If this breakdown cleared things up for you, do me a favor and smash that subscribe button and ring the bell so you're always in the loop. And please, share this video. Send it to every gun owner you know, because these rights only protect us if we actually know we have them. Stay safe and stay informed.